Hi, everyone. Welcome to today's webinar. Today, we'll be talking about navigating the Corporate Transparency Act as a LatAm-based business owner. I'm your moderator today, Reed McBride. To introduce myself, I've been at Carta for 5 years, have a background as a corporate lawyer in Silicon Valley, two-time operator, also an early-stage investor, and have worked on a wide range of projects and parts of the business here at Carta. One part that's been near and dear to my heart has been our LatAm community and how the startup community there has been growing substantially over the past few years. And so excited for a great group of panelists today. I'll let them introduce themselves in a moment here and then dive into the topic we're going to talk about today. But we have Christine Ballard from Latitude, who Latitude's been a close partner to Carta for the past few years, particularly as they've grown substantially in LatAm. Also Bradley Krack, who I've known since my law school days at Berkeley. Go Bears! And it's been great to see Brad build his career at Gunderson, and then Amy Miller, who is a wonderful member of our policy team here at Carta. So, Christine, do you wanna go first and introduce yourself and your background?
Oh, sure. Thank you. And I'm also super excited to be here. Christine Ballard. I guess I've been with Latitude about 5 months now. Before that, I was with Moss Adams. Well, I was on my own for a few years, but before that, Moss Adams. So pretty well steeped in the startup community, have about 11 years of dealing with these LatAm startups, which is super cool. And before that, I was on the East Coast, and I was actually working with Amy as a volunteer with the AICPA, where I was pretty involved with a similar FinCEN effort on the foreign bank account reporting. So here I am again.
Wonderful. Thanks so much for being here. Brad, do you want to go next?
Sure. Brad Krack, corporate partner at Gunderson Detmer. Been at Gunderson my whole legal career since going to law school with Reed at Berkeley. Been here for 12 years. Part of our Latin America practice now. Been practicing law. We have a specialized practice, still covering startups. That's what Gunderson does. Everything related to startups in the venture capital ecosystem. We have a group that focuses on Latin America. I'm in the Spanish-speaking kind of market group based on the West Coast, and happy to be here, meet and speak with you all.
Excellent. And Amy.
Hello, yes, my name is Amy Miller. I'm with Carta, based out of our Washington, D.C. office on our policy team. My background is that I'm a CPA, and that's how I used to work with Christine at the AICPA, prepared returns for businesses, and now I'm on the policy team, making sure that we defend issues, regulatory and legislative, to protect the innovation ecosystem.
Great. We're so excited to dive into this topic today. We've done a prior webinar that you can reference after this one if you like. That also included folks from Latitude and from Gunderson, and we talked about the Cayman Sandwich structure in depth, how LatAm companies typically structure themselves if they want to raise venture capital, if they want to scale operations. And so if you want to go deeper on that, we'll make resources available for you. We won't spend a ton of time on the Cayman Sandwich or why you may want to structure that way here, but just know there are resources available to you. And it's a really interesting topic because why a U.S. law like the Corporate Transparency Act would apply to a LatAm company or a Cayman company is not necessarily obvious. And so it's going to be fun to dive into this today. Amy's going to do a deep dive for us in a moment to just kind of give us the state of the state on where we stand and what's behind this. Before we do that, I just want to mention a couple procedural aspects. One, audience members should feel free to type in questions at any time. And our team is going to be looking through those in the background and making sure that for the Q&A session at the end that we get to the top questions. And we're also going to do a couple of polling questions now just to give our panelists a better idea of who's in the audience and what your backgrounds are. And so our polling questions are, one, where do you work today? So we know where you're from. Two, have you filed the Corporate Transparency Act reporting requirements yet? Have you already gone through that process? And three, did you form a U.S. entity since January 1st of this year? So in about the last 90 days. With that, Amy's put together a great overview on CTA, where we are today. This law went effective in the U.S. on January 1st. And so we're all learning in real time what it means and watching some fun case law develop too.
Okay, I think I will get started with this first slide. All right, enacted in 2021, the CTA, Corporate Transparency Act, requires the Treasury Department's Financial Crimes and Enforcement Network, you'll hear me refer to that as FinCEN, to collect beneficial ownership information, and they call that BOI, from millions of entities. This new law aims to cover companies that do not have an existing regulatory reporting regime in place with the government. So I always say the name is misleading because it's called the Corporate Transparency Act, and people think this is to target large corporations. Actually, it's to target those smaller businesses that don't have a reporting regime with the government. So in effect, the CTA mandate and its reporting requirements will apply to the startup ecosystem and small businesses because those large publicly owned companies are exempt from the reporting. And in some cases with public companies, it's because they already are regulated with multiple layers with government filings. So Congress, who passed this law, and FinCEN are really going after the small, less regulated companies. As Reed mentioned, implementation started January 1st, 2024, and business entities subject to the rules will face significant new compliance and record-keeping obligations. So you may wonder, and we actually got this question during registration a lot, what is the purpose of the Corporate Transparency Act? Why is this happening now? And the intent of CTA is to aid in law enforcement's efforts in anti-money laundering and to combat illicit financing by increasing transparency into the owners of certain corporate entities. And to accomplish this objective, the new rules require companies to report their beneficial owners at the time of formation and then periodically thereafter. And the beneficial owners, you hear this term BOI, they are the people who control a company or hold ownership in it, either individually or through a collective legal entity. So CTA reporting companies could include domestic and foreign companies formed or registered to do business in the US, including corporations, majority of LLCs, partnerships, business trusts, and other non-public corporations. And this was kind of a chart to help you decipher, am I a reporting company or not? Okay, these are the, on the left side, it's the filing deadlines. And we kind of put it in order of what is the first ones to worry about. So basically companies formed this year in 2024, newly formed 2024 companies in the US have only 90 days from their day of formation or incorporation to file with FinCEN. And then the next deadline will be companies that are existing, so formed prior to January 1st of 2024. And those companies have until January 1st of 2025. So you have a whole year to file. And then you have new companies starting January 1st, 2025 and later. So if you plan to incorporate your business in Delaware and the US after January 1st of 2025, you only have 30 days to file with FinCEN. So that 90 days shrinks down to 30 days. People have pushed back to FinCEN to ask, why is this deadline so quick? And their response is, well, when you're forming your business, you know who the owners are. You have all that information readily available. Why not file this information while you have it handy? That is their explanation. And as I mentioned, there's refiling involved as well. So if any of your information changes for your owners, you have 30 days to refile with FinCEN that updated information. And on the right side of the slide, you'll see the company details that will need to be filed. So all beneficial owners, and that would be if you have 25% or more ownership in the company, or if you have substantial control. And we'll go more into detail when we have a panel discussion about substantial control. And then also there is company reporting and also company applicant reporting that is required. I put this here just as a reference for substantial control. We'll talk about this more in detail. All right, and then very quickly, a policy update. So many of you may be here on the session today because you've been hearing about CTA in the news and you've been hearing about lawsuits. So recently in the news, a federal district court in Alabama held that the Corporate Transparency Act was unconstitutional. And this has created uncertainty and a great deal of confusion for businesses as to what the filing obligations are for CTA. And we can expect this should just be the latest in what will be a longer legal saga. So what are the implications and what do you need to know right now? Well, FinCEN announced that it is complying with the Alabama court decision and not enforcing the CTA against only the plaintiffs of that lawsuit. So that's about, I think, 65,000 members of the NSBA, the National Small Business Association, while all other reporting companies are still required to comply with the law and file beneficial ownership reports. We expect additional challenges to expand that class of companies that are protected from enforcement are likely to arise as more businesses and individuals try to file suit as well. One thing to note, state laws that mimic the federal CTA reporting requirements, such as the New York LLC Transparency Act, which is already starting implementation, are not affected by the court's decision. And proposed bills in some states like California and Massachusetts could also implement state level beneficial ownership reporting that would not be impacted by any federal court rulings. So the most important thing to know is that most new businesses and new business entities formed in 2024 are still bound by the CTA and should plan to file with FinCEN within that 90 days of formation until further notice. And businesses should discuss their filing obligations with legal counsel. Okay. And very quickly, I do have a link on the very last slide to a resource. We have a compliance checklist, but this is kind of the steps to go through for filing. First, determine if you're a small business that needs to file the BOI report. Know your company's entity structure, LLC, corporation. There are exemptions, but what we want to say here is that most small businesses will be required to file, will not fall under one of the 23 exemptions, which really include larger companies. Next step, determine your beneficial owners. So whether 25% of ownership or more, or substantial control, determine who those owners are. Seek legal counsel for advice if you're not sure. Third step, gather the information for reporting. There's required company information reporting, and that's company name, trade names, U.S. address, U.S. jurisdiction information, and your IRS tax identification number. There's company applicant reporting. So that is the person who directly files the creation or registration document with a Secretary of State or similar office. And if more than one person is involved in the filing or creation or registration of the company, you could have up to 2 company applicants that will also need to provide their name, address, and a form of ID. So it could be a passport or a driver's license. And then most importantly, the third reporting is the beneficial ownership information reporting. So that's full legal name, address, date of birth, your official document, whether it be passport or driver's license, and yes, and then the jurisdiction where you're issuing that your document. So it could be whether you have a foreign passport or a U.S. passport. Okay, step 4, you want to file information within those timeframes that we discussed. So if you're an existing company, you have 90 days from formation. If you're an existing company before 2024, you have 1 year. Your deadline is January 1st, 2025. If you're a new company formed in 2024, you have 90 days from formation. If you plan to incorporate in 2025, you will only have 30 days. And then finally, keep that information updated because CTA law requires that you maintain your records for 5 years. And CARTA does have a filing solution and a tool. So if you do it through CARTA, we will actually maintain your records for 5 years for free. So that is one thing to note. But put the slide here just to kind of show what our platform looks like if you use it to file your CTA report. We make it very simple. And we're really here to help the ecosystem painlessly navigate CTA compliance, including offering this free CTA filing service. And we will help maintain the records for 5 years as well.